Welcome. We're glad you're with us this afternoon. I have the distinct pleasure of welcoming Rick Wood. He's an estate planning and family law attorney, as well as a dedicated Phelan-McDermid syndrome dad. Rick brings invaluable expertise and personal experience to help families navigate the complex legal landscape surrounding guardianship, estate planning, and special needs trusts. So please join me in welcoming Rick to the stage. Thank you, Rick.
Hi, everybody. I apologize for my uniform here. I had back surgery 4 weeks ago, and I'm managing, and I'm here. How many people, first of all, I'm glad you're here. How many people have seen me give this presentation to this group in the past? Anybody? All right, so this will be similar. It will be different because I have decided that in order to speak to people from 50 states, I need to keep this generic, and I really want to plant some ideas, trigger some thinking about what we call estate planning. And I've got a whole bunch of topics, as you will see, that I want to cover, and there's a lot of information. So what I'm going to try to do, maybe successfully, is keep my presentation to about 30 minutes so that we can have time for questions, because I know from experience that there are going to be questions. Before I do that, I want you guys to know, well, first of all, my son Davis is 29 years old in August. He was diagnosed at the age of 3.5 at the number 34 in the world. And as you can imagine, we didn't know anything all those years ago. We know a whole lot more. And so we have a lived experience. My wife Cheryl wrote a book called The Tao of Davis. It's in where they are dispensing the wristbands and the other things that you can buy. You can buy this really cheap. Should you buy this? Well, mothers tell me that they cry at the third chapter. So it's in my mind, it's our tale. It's a tale of our family over the last 20 years or so with PMS. So if you're interested, I understand it goes for $10, but if you don't want to pay $10, I understand that they will give it away. We donated a bunch of books for those that it might, or that its subject matter might resonate with. So here we go. See if I can manage this. I can. So the title of this is Special Needs Estate and Family Planning. And so in this overview, I've asked a bunch of questions. The first is, what is it? Well, it's planning for your future, your family's future, most importantly, your child's future, because what we know now that we didn't know 25 years ago is that these kids are probably going to outlive us. And so we need to have an understanding. No, we need to take some steps to protect them after we are gone. Who needs it? Everyone. When? Now, not later. Somebody came up to me at the conference, at the session that I presented a little earlier, and he said, I'm not going to be able to be here this afternoon, but I have a 2.5-year-old. Should I get started now? Is this something I need to do now? And I said, yeah, because you can pass away now. And it's not likely. Most of us live to, our life expectancy. But I said, but there is something that you can do even before you begin to put an estate plan together that would include a special needs trust, and that is buy insurance. I don't sell insurance. I'm not a broker. But under these circumstances where we know we're going to have tremendous financial needs for the rest of our children's lives, you can buy insurance that is cheap when you're younger. It's real expensive at my age, but term insurance is cheap. And so I promote it, and I'm pretty forceful about that because I have known over these last 25 years what it has taken, what the cost has been to take care of my child who is no longer living with us but is a mile away. Where to plan? Well, the second thing that I told this gentleman this morning was, I'm from California. We have 49 other states plus the District of Columbia and a couple of territories. The laws in estate planning are basically come from the federal government because they're tax related, even though most of us will never pay an estate tax because the exemption equivalent, or the amount that we can own at the time of death, is so high. It's over 16 million now for one person, and if a trust is done correctly, 32 million for a couple. So most of us do not fall into that category, and we don't do tax planning for the most part for most people, but we do want to have a planning in order to make sure that your child who is left something, the something could be small, it could be big, or anything in between, is not sucked up by the government, which is responsible for providing public benefits to your child, okay? All right. What am I going to talk about? Special needs trust, able accounts, conservatorship, what I call a memorandum or letter of intent, which is maybe the most important document on that screen, and then a couple of additional items, housing costs and protection of public benefits. All right, so we're going to start with a special needs trust, and I don't have a screen in front of me, so I'm looking as you are. Okay. A lot of people think, well, do I need a will? Okay? A will in most states will do what? It will transfer your property to your heirs, and it will name an executor, somebody to administer your estate. A will is a subset of modern estate planning. The real foundation of estate planning is a living trust. I'm sure you guys have heard this term over and over again. Many of you may already have them. And essentially, a living trust is a document that is revocable or revocable during your lifetime, in which, and it looks like a will, except it's a lot longer. You say who your kids are, if indeed your kids are your beneficiaries, and could be any beneficiary. You say how is your estate going to be managed when the first of you passes away, and when the second of you passes away, where does it go, and when, and how? Well, that looks like a will. So we don't really need them any longer because we have because wills in estate planning are now called pour-over wills, meaning if there's any asset that is left out of the trust that you've created during your lifetime, the will pour into the trust all of those assets, because we want to have an instrument that is going to administer your estate over time without subjecting that portion of your estate that goes to your special needs child to exposure to the federal and state government that is providing public benefits, okay? There's two types. Okay, first-party special needs trust usually happens when, for example, a grandparent wants to give a grandchild money, right? It's kind of like if you set up a 529 education plan. The grandparent says, I really want to make sure that my grandchild has some money. Or in the case of people with special needs that arise out of, for example, an auto accident where they're not capable and they're injured and they will be for the rest of their lives. So that's a lifetime, or what we call first-party special needs trust, where you just set up a trust during lifetime. Assets go into it. The beneficiary of the trust is the individual with special needs, in our case, our children, right? And so the idea with a first-party trust is that it will provide funds in excess of what you need, or in excess of the money that is provided by the government, whether it's federal or state, to meet the needs of your child. And we know those needs are big. So those are less common than most special needs trusts, which are third party. Third party works like this. So you set up a trust, looks like a will. It's got an estate plan in which you have an order or a plan of distribution, and the portion of the trust, thank you, the portion of the trust that will go to your child is a subset or a special needs trust inside of the trust. So instead of giving it to a child immediately or over time, that is a typical child, you will have a special needs trust that segregates the estate, and so there's money for the child to supplement but not supplant federal and state benefits. So it's really as simple as that. It's as a concept. And so when you go home, first thing I tell people is go find a lawyer with estate planning experience. There's lots of lawyers with estate planning experience. Find one with special needs trust language, because the language has to be perfect within the parameters that are prescribed by the Internal Revenue Code in order for it to work. Because essentially what you're doing is you're taking all or part of your estate and you're putting it over here, and you're saying, if there's not enough money coming from public benefits to meet my child's needs, whether they're medical needs, behavioral health needs, financial needs like paying rent or a mortgage, food need, whatever it might be that relates to that person's living expenses, right, are sitting over here, and the trustee, who's the equivalent of an executor, you hear that a lot. A trustee is the person that then doles out the money to supplement but not supplant those benefits. And the government can't take them, because there are a lot of programs out there like Medicaid where you can't own any assets over $2,000. You can't have any income in order to qualify. And so as a practical matter, what you are doing is you're creating something that is irrevocable or irrevocable for the benefit of a child. And so that's the concept. The concept is easy. The language is tricky, which is why you need a lawyer that's got experience, okay? So once you have a plan in place, there's a bunch of documents, as you guys will see, that go along with the trust itself. And again, a trust during your lifetime is revocable. You can change it. You can change the beneficiaries. You can change the order of distribution. You can do a lot to, if you will, control your assets after you're gone. And that's great for everyone, because it's certainly more flexible than giving children lots of money, or even a small amount of money, but what is a lot of money to them, like at the age of 18, right? So in our case, the important thing is that you maintain control over the distribution of your assets, and you do that by way of a special needs trust. And so the way I want you to think about it is, you have a trust, special needs piece of it inside of that trust that is set up for the benefit of your child with disabilities. And you can decide however much you want to do that. So when I created my trust, we had one because we had older kids, and our son Davis is the youngest, and so really all I did, it's very typical for a family to say, okay, I've got 3 kids, I'm going to divide my estate 3 ways. You can do that. You can also say, I'm going to give the first X dollars or X percentage of value to my son with disabilities, and then the rest of it will be divided among my other kids. It's unlimited almost as to what you can do with your assets, but with respect to the special needs trust, again, it is in order to protect your assets from being swallowed up or taken back or clawed back by those entities that are putting money out for your child. Here is an alternative. Has anybody heard of an ABLE account? All right, so it's become pretty popular. So in 2014, federal government passed an act, which is Achieving a Better Experience Act of 2014. They always have these names that turn into acronyms, and here we are. And so what this was originally called the poor man's alternative to a trust, which I always thought was stupid, because I think these things really work independent of a living trust or together as another kind of tax-deferred account for the benefit of the child. And essentially, it works kind of like a 529 college plan. So you put money in up to $17,000 per year, and then that money grows tax-free. So there's no deduction when the money goes in. Money grows, and when you take it out, which can be for anything related to the person's health, welfare, safety, education. When you take it out, you're taking, there's no tax, it is not taxable. So the earnings and accumulations, the appreciation is not taxable. And so it's a great account. The problem, not really a problem, but there are limits. First of all, the person who is the beneficiary, who would be your child, and by the way, these are accounts that brokerages set up all the time. It's not dissimilar from the 529 education accounts. It's the same section, different subsection. And essentially, you have to have a diagnosis by age 26 in order to qualify. That's changing. I think it's next year, I'm almost sure, to 42. Secondly, you can put that in 17,000. It grows. That number goes up. I think next year is 18,000. You can put money in, and it can grow to 100 because you can have $2,000 to qualify for Medicaid. You can have $2,000 worth of assets. Only two. You got 2001. You don't get Medicaid. And in the session that I was in this morning, we were talking about that. I mean, our children qualify independent of our financial circumstances, our incomes as a family. They qualify for Medicaid. It's called Medi-Cal in California, same thing, federal money administered by the state, and there are, prescribed amounts. Well, because they are public dollars, you can't own anything and you can't earn anything. Well, we know our kids don't earn anything, and we don't want them to own anything. So the ABLE account allows you to put in $100,000 up to $100,000. Now, this account can't grow to something in excess of $102,000, because if it does, you go over the limit, you're disqualified from your son or daughter is disqualified from receiving assets. So how does it work? Well, if you put in $10,000 and it grows and you want to use some of those funds, you can take those funds out at any time. If you put in $10,000 a year and it grows and grows and grows, and after a period of years, you're approaching that $100,000 mark, you need to take money out because it can't be over $100,000 because it's technically 102 if that's the only asset that the child has. So, but I think it's a great program. It was passed in 2014, and the states have slowly but surely adopted the implementation, and all states are different, but it's all the same. They go by the federal rules. You can go to Merrill Lynch, you can go to Fidelity, you can go to any place, and they will set up an account. Do you need to put a minimum amount in? No, you don't. So I think they're important, and it's an adjunct to or something that you can do in addition to a family trust if you want to. Again, the idea is we're going to grow an asset by having the earnings and accumulation, the appreciation, be in an account that is not going to be subject to attachment by either the state or the federal government in exchange for providing public benefits. Okay? All right. So I have this in here, this conservatorship in here, because this is a document that is really important during lifetime. So here's the concept. Guardianship is for kids under 18. Conservatorship is for adults over 18 and over. And in some states, they actually call conservatorships guardianships, just a few. But in most states, there is a distinction, but it's just based upon age. Now, if you're a parent, as we are, you don't need to have guardianship for your child because you, as a matter of law, have the right to make decisions on behalf of your child. In fact, a child lacks capacity to contract until age 18. So there isn't any reason for anybody to enter into a guardianship. And so we look at conservatorships when people age up, when kids age up to 18, because someone needs authority to make decisions on their behalf. Conservator of the estate and conservator of the person, okay? Now, I could argue that every single person in this room is the sole decision maker for his or her child, because our kids can't, they lack capacity to make any decisions. So the question is, well, why do you need that? Well, if you're going to set up an account, for example, you're going to need to make a decision, apply for something on behalf of your child. Or if you go to the hospital and somebody wants to know who's got authority to make the decision to have surgery or for any other kind of treatment, they want to know who's got that authority. There are many people who don't do conservatorships because they don't feel like they need it, because nobody ever questions whether they've got authority to make decisions on behalf of their child. And I think there's something to that, because a conservatorship actually takes civil rights away from the child. Can't make any decisions. As a result, there's a debate now about whether a conservatorship makes sense for people. In other words, if you can get along without one, why would you do one? They're really expensive, and you have to go to court to get them, and they're tedious. I mean, my firm does them as part of its family law practice, but we don't like doing them because in California there's just lots and lots of paper. And then every 2 years you got to report back to the court. You got to say how the money was spent or the other assets, what the income was, what is left over, and you have to establish every 2 years that your child is still in need of a decision maker. So I don't like conservatorships, but I am a conservator of my child, as is my wife, Cheryl, because somebody is going to ask us one. We live in a very small town. We live in a mountain resort in California called Mammoth, and everybody knows us, and everybody knows our child, and there isn't any question about who's got the authority to make decisions. He certainly can. He can't speak, as you know, and however, what if we're somebody else? And I remember one time he had a seizure on an airplane, and we landed in San Diego, and there were 15 paramedics out there swarming us because they didn't know how to handle this, and that's what happens on airplanes. And I thought to myself, if I didn't have authority to make the decisions, I wonder what would have happened here someplace outside of Mammoth. So this is for parents whose kids are over the age of 18. It's something to consider. I can't tell you whether to do it or not. Read up on it. We're in the age of Google. You can find out anything you want to, whether it's true or not. You're certainly going to become informed, okay? Next. This is like my favorite part. I'm going to tell you how it works. So when Cheryl and I put our plan together, one of the issues that we thought was most important, and I couldn't find a place for it in a trust, was to say to whoever survives us to say something about our child. Well, what are his medications? More importantly, because he doesn't speak, how does he communicate? At that time, he was not toilet trained. What do we need to convey or impart in order to make it easier and therefore give us peace of mind to care for our child? And, we're all doing it. Whether, the diagnosis was 6 months ago or whether it was 25 years ago, we know our kids to the extent that we can, and that needs to go down on a piece of paper. And I didn't know how to do that. And because you don't want to put stuff in a trust if you need to change it later, and we know the changes are made, because you have to go to a lawyer and have the lawyer redraft, either to amend the trust or to take something out, right? And so what a memorandum of intent is, it's just a piece of paper that says things that you think are important for somebody else to know if you are not around to do what we do now. And it's just a piece of paper. It goes on top of the trust. You want to change it, you want to add to it, you don't have to go to a lawyer's office. You simply amend it, and you sign it, and you date it. And those instructions will be followed by the trustee, because the typical trust says if there's a memorandum or letter of intent, you got to follow it. It's as if it were drafted or included in the document itself. And so this is the most personal, and I think the most important piece of information that you can leave behind. And the time to do it, I send people home with estate plans without kids with disabilities. And the time to do it is at the time that a plan is set up, or after that time, because you don't need a lawyer. Here's another example. Let's assume you don't have a child with disabilities. But you want to give to your daughter your wedding ring, and to your son your hunting rifle. Doesn't matter what it is. Well, we don't want to put that in a trust, because every time you get a new rifle or more jewelry that you want to give to somebody specifically, you have to go in and change a schedule or change your trust, which costs money. And the idea is you don't do that. I mean, periodically a trust can be updated, but we don't want to have that information in a document that is expensive to modify. So what you do is you put it on a piece of paper. I give my binoculars to my son. I give the grandfather clock to my daughter. You can be very specific about that. And most trusts now will contain a paragraph that says, hey, if there's a list, which can go right into this memorandum, if there's a list that's attached to this document, trustee, you distribute in accordance with the list. If there isn't a list and the trust says divide everything 3 ways, then the trustee gets to make that decision. All right? So that is literally an everyday thing. And I advise people, look, once a year you probably ought to take a look at your documents to find out what is really important to you. I don't really care about stuff. I don't think my kids much care about my stuff. I think they're going to throw my stuff away after I pass. I think, on the other hand, they really care and need to know everything that we can say about our son. And, some people, you could record a video, you could record an audio, you could put a tape. Of course, by the time I die, the tapes won't work. There won't be any such thing as a tape. There hardly is any anyway. Now, anyway, so I think it's a really, really important document, and it is easy to do, and only you know the most about your own child. Okay. All right, so I added this housing thing because it's no secret that there's a housing crisis in most of the country. In California, in particular, the affordability of housing is, and many other states as well, is just terrible. And so I can't solve the housing crisis, but here's what I think is important for me to impart about housing. And I'm going to tell a little story. Our son, almost 18 years old, we had the annual meeting of the doctors and the nurses and the therapists and everybody that we used to have this annual meeting with. And at that time, of course, he was still in school. And this nurse that I've known for a long time came up and she said, so, kind of hesitant, have you thought about what's next? And I didn't get it. And I said, well, what do you mean? I guess I thought about what's next. I don't know. Of course, at that time, like all of us, we're just living day to day. What's next? She said, well, your son is probably going to survive you. And I said, yeah? Well, where's he going to live? He's living with us. End of conversation. He's not living anywhere else. No one can take care of that child like we do. Well, she got it and didn't say anything. Meeting ends. But we started talking about it. It took us 5 years to make the decision to move him out of our house, 1 mile away. Why? Because he has a seizure disorder, and he fell downstairs in our town because we get a lot of snow. Houses are multi-level. So we see a picture of him laying at the landing after having a seizure, along with the caregiver laying next to him. That was it for Cheryl. She said, I didn't want to do this. I don't want to leave him. I don't want to lose him. We're going to go find a place. Well, that's great, except that it's hard to find a place that anybody can afford, right? Especially in a ski resort. So we managed, just by a stroke of luck, to get into workforce housing, even though Davis doesn't work. But we employ 9 people who take care of him. And we were able to finance that, and he and we are not only happy, but for the first time, 23 years, we actually were able to take a vacation together. You kind of forget what that is really like, you know. And why? Because we had confidence that the people who were caring for him we're going to be able to do that in our absence. And as Cheryl has said, you know, it takes 9 people to do what I did for 23 years, which that's humbling. But I went to work. So the point is that, is this. Independent living is an option if you can afford it, if you can find it. Look into programs in your town, in your city, in your state, and start thinking about it, because the unthinkable for us at the age of 18 was that he would ever be apart from us. We didn't know whether we could handle it. We didn't know whether he could do it and whether he would be able to be cared for. And frankly, it's the best thing that happened. And I learned that from a guy who's not at this conference, a retired doctor. His child was about 40, and he brought his child to a conference. And 2 years later, we have a conference, and he didn't bring his child and said, hey, you know, how's your son doing? Because I didn't know. And he said, oh, he's doing great. I said, yeah, you didn't bring him this time. He said, no, I didn't. I said, you know, why? He said, because he doesn't want to come, for one thing. And secondly, he doesn't live with me. I said, you got to be kidding. This is long before my son was 18. He's not living with you? How could you do that? And he said, well, we placed him when I believe he was about 14. And it had been a couple of decades in a group home 40 minutes away, and he said it changed our life, and it changed his life for the better. That was the moment that we started talking about, oh my God, he's going to outlive us. Are we going to foist him upon our children? Well, I don't think either one of our children want to have that responsibility of taking care of our child, because we know what that responsibility is, right? So independent living, there is in many communities what we call Section 8, which is subsidized housing, that our kids will qualify for, because once you reach the age of 18, your income, which is SSI, a supplemental security income, is going to be low enough to qualify for Section 8 housing. However, most of the waiting lists go for years and years. Group settings. Okay, that's the big thing now. You know, decades ago we had institutions. We would put kids like ours in institutions, whether they're adults, children, what have you. Those are all gone now. We don't have those. But there are group homes of typically around 5 people. I've talked to a lot of people, even in this conference, whose children or child is in a group home. The reason I put inclusion issues there is that the theory now is that we do not want to isolate people with disabilities. We want them to be included. It's kind of like at school, you know, the kids are in the classroom integrated with other kids, although in our school that didn't happen. There was a special ed classroom, but they integrated nonetheless in the school population and other things, even though they were taught in a segregated classroom. And then finally, a child can live with a parent, and I know this because I see people. One of the things that strikes me about this conference is that there are a lot of first-time. How many first-timers do we have here? Look, it's amazing. We didn't have first-timers. We had this, we had a lot of first-timers, but as it has grown, the number of first-timers has gone up, and significantly, there are many in this conference whose diagnosis didn't occur until the child was over the age of 18, right? And so there isn't anything wrong with living with parents, siblings, and caregivers. It's an option. I don't think you have to rush out if you've got a 5-year-old and figure out what you're going to do 13 years or 15 or 20 years from now. But I do think you have to have it within your community in mind, because the reality is our children are going to outlive us. What are you going to do? And every family, every circumstance is different. And you will make a decision about what to do either after that child ages up. In our instance, it was 23, or it's something that may happen even before then. Okay. All right, public benefits. We did a session this morning on decoding. I just had put this together to talk about the things that are available. And those of you who are in the morning session, I opened with advocate, advocate, advocate. You must advocate, and you must advocate more and more and more. So you get online. That's what we have online for now. And you find out what is available for people with disabilities, minors or adults. Early start, that happens in many instances from birth, because now we have a diagnosis. We don't just have a hypotonic child, we have a diagnosis. It's a real thing. And so why is that important? Because we know how hard it is to have these kids full-time, 100% of the time without any help. And we all need it. Public education. Well, that's really important. In most states, a person can go through school until the age of 21 or 22. And that's great, because 6 hours a day, there are things that your child is going to be able to be involved in, and it's a generic resource, meaning it's available to everyone because public education in this country is free. So what happens later on, beginning with the moment that it makes sense to you to have him in programs, is that the school coordinates those things. So if there's a day program that you think is important for your child to go into, you want to find out in your community who's doing those. What are they doing? Is there direct supervision? Is there enough supervision? There are a lot of decisions to make when you are thinking about leaving your child in the care of somebody else, obviously outside or away from your eyes. I've got this line in here called entitlement versus need-based programs, and the reason I do that is that Medi-Cal, that's insurance, is need-based. Not everybody can have it. If you have assets, you have income, you can't qualify. You can under certain levels. That's the classic need-based program. When a child ages up to 18, SSI is an entitlement program. An entitlement program. Everyone gets it. And the amount of it seems to me that ours was, every state is different, because they administer the federal money, but I think that he was receiving, when he turned 18, about $850 or so a month, and that went up by cost of living and so on. Later, he converted to Social Security as an adult dependent, because I aged up to 65 and was receiving Social Security. So they do a recalculation, and the calculation is that if he would receive more as a dependent under Social Security, he would have his own Social Security income. If he would receive more under SSI, which is an entitlement program as well, he would have that. So the number never went down. In our instance, it went up. That's the difference between those two. Question, Medicaid or Medi-Cal in California in jeopardy? Okay, well, we live in a political world, everybody. I mean, There are many people out there who think that there are some politicians out there who think that Social Security and Medicaid are the programs that need to be cut in order for the budget to be balanced on federal level. Do I think that's going to happen? It's not for me to predict. Obviously, that's something that's going to be really, really important for all of us. Medicare, Medicaid, Social Security, things that are entitlement programs if you qualify, and in some instances without having to qualify, like Social Security, other than to age up. And so I put that out there because really in the end, it seems so crass to just talk about the money. But I've said it in many conferences, which is, all right, let me be crass about it. It takes money for us to provide an opportunity for our children to live their best life, right? And most of us can't afford what it will take, including, in our instance, 24/7 care with 9 caregivers who are there 168 hours a week. And so what is important is that you find out what's available everywhere, and you advocate again, and you don't allow people to say no unless you understand the reason for that. And that's the advocacy piece. And, you know, I often say, because I'm, as my wife knows, am really, really steeped in this thing called self-determination in California, and have been now for a decade since it became law. And so I see people with disabilities, there's nearly 400,000 of them in California who are receiving benefits or services and supports. And in almost all instances, they need help. They need outside help. And I think in the last session, somebody asked me, you know, do you feel guilty, or maybe I feel guilty about taking federal money? No. We're a community of 250 million people. The government puts it out there. It's available. You owe it to your child and to yourselves as a family to get, if you will, what you can. That doesn't mean you take advantage, doesn't mean that you steal, doesn't mean that you commit fraud. It simply means that you investigate programs that are available that will help you defray the cost of living your son's or your daughter's best life. That's the advocacy piece. So, all right. Transition planning. We talked about this a little bit at the top. You know, at the age of 18, almost 18, you know, the question was put to us, what's next? Well, it took us a while to figure it out and to accept the fact that, my God, he really is going to live, probably, unless he, you know, goes down by way of a seizure or something. He's actually going to live longer than we. It's just not a concept 25 years ago, you know. So where is he going to live? What's his income going to be? I'm going to tell you it's going to be SSI. But $800 and maybe $900 a month now is not enough to support anyone. It's still well below the poverty level. I spoke about the special needs estate plan. Remember, I'm going to go back to the beginning. Segregate your assets when you die into the ones that are going to go to your child into a special needs trust inside of your estate plan in order to keep it from the clutches of the government. We talked about conservatorship, which is an option once your child ages up to 18. And here's the most important one, and that is, we know this, family circle of support. Who is in your child's life? It is those people that you want to know the most about your child, and those are the people throughout his or her life who are going to take care of him. At least we hope so. Because why do we plan? Because we're not going to be here to plan later, and so we want to have some sense that things are going to be okay. We've gotten to a point, I think I said it in the men's group, in our lives where we have sort of figured it out. Meaning, you know, we know the challenges are going to come. I don't know when he's going to go in the hospital next. I don't know when he's going to have his next seizure. I can usually predict it's going to be soon because he has a lot of them. I don't know when. He never got COVID. 9 people coming into his house, but we worried about it. Could he survive in the event that he had a chest issue? And so But where we are now is we've gone through it. Our kids have gone through it. And for those of you who have very young children, I want you to know that it's going to be okay, but you got to work at it. All right. Management of the fear of the unknown. Well, we have a little debate in our family about that. You can go to a dark place all the time. So who do you think goes to the dark place? It's my spouse, because that's what mothers are entitled to do, right? I just go, okay, we're just going to take whatever's coming as it is. And the fear is legitimate, but it also feeds the need for you to think about estate planning. As lousy as it is, I will tell you this, people who walk out of my office in my little town who put together a plan and we put their documents into a notebook and we've got durable powers of attorney and wills and trusts and all the documents to fund the trust or transfer assets into it, I often hear, I just feel great. That's compared to every other kind of type of law that we do, which is that people are just unhappy. Litigation in particular, and family law in particular as well. There's no happiness. But there's happiness because you get or gain peace of mind. You've done something that is going to outlast you. And frankly, you owe it to your family and yourselves to do that. So that's all I have. I'm happy to take questions. My email address was up on the screen. It's rick@woodlawgroup.com, rick@woodlawgroup.com. Send me an email if you have a question. And again, I practice in California. I don't know other states, but estate planning is a very static, stable kind of area because it is based in part on the requirements from the Internal Revenue Code, which is, of course, a federal law. So that's the best advice that I can give for those of you who are not in California or for those of you who are. Questions?
Thank you so much, Rick. So much to think about, and I know it can be overwhelming, but I think you did a great job of breaking down some of the really important basics. Yeah, thank you. So you guys probably know the drill by now with Poll Everywhere, so go ahead and use that QR code. It's different from the Lakes Ballroom code, so if you've been using that one, just scan this one, and we can go through the questions as they come up. So our first question is, what happens to money in an ABLE account if the child dies?
That is a great question because I didn't cover it. So here's what happens. An ABLE account is like a retirement account. Think of it that way. So if you have a retirement account at work or if you set up an IRA, that's a contract, and you name a beneficiary. Retirement accounts don't go into trusts, although trusts can be beneficiaries of retirement accounts. They're owned by individuals. So it's the same thing. You name a beneficiary after the child passes, or beneficiaries. You can name them together or in order. So, for example, very typical would be that the balance in the account, whatever the assets are, would go to siblings. And if you have another disabled child, it can go to the other disabled child tax-free, and that child with disabilities can take advantage of it.
Okay, we have a 529 with money in it under her name. Any way to transfer it to an ABLE account?
I don't think so. The subsections of 529 are independent of each other. I'm not aware that you can do that. An accountant will be able to tell you that.
For SNT, do you have to file taxes on that annually if you fund it?
Yeah, so a special needs trust is part of a revocable or revocable living trust. It is not a separate taxpayer. You do not pay taxes. It's as if you are the owner, just like you are, of your assets. It could be a house, it could be a bank account, it could be a vehicle, it could be any of your assets, and it's as if you own them as opposed to someone else owning them. And so, not only can you change it during your lifetime, but it doesn't file a tax return. You file your 1040 every year. just as you would if you did not have a trust. So, yeah, it is not a taxable account.
We already have a special needs trust. Should we still consider an ABLE account?
Yeah, I think that's a question I get once in a while. You know, we have not set up an ABLE account. You know, if my son had grandparents who wanted to to contribute to an ABLE account, it makes sense. For me, we have a coordinated estate plan in which the plan of distribution is what it is, and so we haven't felt that we need it. But what's the value of the ABLE account? It is that the assets that are put into it grow tax-free over time. So ABLE accounts in California didn't happen until 2018. Well, you know, if you have a child who's 1 or 2 or 3 and you can grow an account, I think it makes sense, but it's not something that made any sense to us because of his age and because of our ages, and so we're simply covered. But sure, they can go together. One can be the adjunct of the other.
Did we answer this one already? Should we stop putting money into a 529 and switch to ABLE? Any reason not to?
So ABLE is a 529 account. 529A is the section. And so that's independent. That's separate from a 529 education account. If you think your child's going to go to college or trade school, set up one of those. Mine won't. So it's an alternative.
Can our minor child be qualified for Medicaid, or do they have to be over 18?
Okay, so, you know, there's a lot of misconception about this. Now, so I'm going to tell this story I told this morning, and that is for the first 3 years of our child's life, we had big medical bills, lots and lots of problems. And we had an insurance policy, right, that was through my law firm, where we had co-pays and we had deductibles, and I just never stopped writing those checks for 3 years. I felt like it was another mortgage. And I thought, well, that's just the way it is. And of course, I'm a lawyer, but I wasn't into the advocacy world at that time. Somebody said to me, well, why isn't your child on Medi-Cal, which is Medicaid in California? I don't know. I imagine because we make money and we have assets, and therefore he can't qualify, because I was under the impression that it's the family income that is important. However, PMS it qualifies for what is known in the law as a compassionate allowance, and it specifically qualifies now for Medicaid independent of family income and assets, provided, right, that the person doesn't have more than $2,000 of assets, provided that person hasn't any income. So short answer is yes. So early on, I heard somebody talking about, you know, deductibles, and they don't have those in Canada, and we have them here in the United States, and so on. It's got to be, you know, so we've got this burden. Relieve yourself of the burden. Go down to the office that administers Medicaid in your community and say, I understand that 22Q qualifies, is a qualified compassionate allowance syndrome, disease, disorder, call it what you will. I would like to get him or her on Medicaid. And I'll tell you, because we've had lots and lots of medical issues since then, we haven't paid a single bill since he was 3 years old. Not $1 in medical. No, I mean, when I think about the cost, when I think about $10,000 a year for the past 25 years, well, that's a big number. And so we don't pay it because we don't have to, because our child qualifies.
I just want to add to that sometimes the law is one thing and what is written down in policy is one thing, but it can be really, really hard for families to navigate the path to get there. So if you have trouble with that, if you're told, I know in Florida, they make it really, really hard. they want you to mess up and say that your child does have assets. So we have reps at PMSF, state reps and others. You can reach out to me if you need help navigating that process in your state with someone who's done it before and who understands how the process works.
Yeah, thank you. That's really
Yeah.
good. And there are people in every state that will do this. And by the way, you know, there are also advocacy groups throughout the state. I had a question at the morning session, which went something like, you know, I'm going before a judge to get to challenge a denial of a mobility device, I think was the question. You know, what do you do? And I said, in every state, there is one or more organizations in California, actually funded by Sacramento, funded by the state government, who whose job it is to advocate for those who are in the system when they need advocacy. And so, you know, you have to go to somebody who's got experience and who has become an expert in the field, because this stuff, all the other things we have to do in our life, this stuff has to be done as well. And, you know, you get good at it after a while, but unfortunately, we all need a little help.
Okay, if we have about 5 minutes left, so there's a bunch of questions. We might not get to all of them. If we already have a 529 education account prior to knowing our options, what can we do with the money sitting there, assuming our PMS kid won't be going to college?
I don't know the answer to that question. I just don't. Somebody might know. Oh, yeah.
Okay.
Yeah, that's right. I was assuming only one child. You're absolutely right. But I don't know what you do with one child. There you go. Well, it doesn't just go to the state. That's not the way it works.
I thought the individual had to consent to conservatorship. I believe it's called guardianship in Ohio. Are you saying we don't have to get anything even if your child is more severely intellectually disabled?
No, the purpose of conservatorship is for a person to take on to act in place of the person who cannot act because that person lacks capacity. Now, lack of capacity is a legal term. And so the question is never, do you need consent? The question, although in some instances we actually get consent, but think about this. If you can't give consent because you lack capacity, right, why would you need to get consent? The purpose of conservatorship is when a person cannot make decisions on his or her own, for someone to make them for that person, and consent is not required.
I think that's a really good point that Rick just made as well. My husband's an attorney, some of these legal terms can sound really, really harsh, and when you hear lack capacity, it's, no, my son has capacity, but no, it's just a legal term. It's literally something that the lawyer has to use to define it in that way.
Yeah, it just means that you're not capable of signing a contract.
Yes, exactly. Thank you. Does the MOI, LOI have to be notarized?
No, it does not.
For keep going.
Go ahead.
For SNT, do you have to file taxes on that annually if you fund it?
No, it's revocable unless it's a first-party SNT. So remember I said at the very beginning there's two types, first party and third party. Third party is when you have it in your trust, in your will, right? After you die, it kicks in. Assets go into it. A first party is one that's funded during lifetime. It's an irrevocable or irrevocable trust, which means that it will pay taxes. It's not a tax-deferred account like ABLE. It will pay taxes on its income as that income is received, whether it's dividends or interest and so on. And so as a practical matter, and by the way, trust income tax rates are higher than individual income tax rates, and are even higher, well, now we know really higher than corporate tax rates, because there was a corporate tax cut during the Trump administration some years ago. And so I don't do a lot of irrevocable trusts or first party trusts, because they're really effective if you get into a car accident and you're in a coma and you're incapacitated and you're going to live, right? And it's somebody else's fault and you get $1 million settlement. Well, that's where they really work, and so you pay the price for that, which is that if there is income that is derived from that, taxes are paid by the trust as a separate entity.
Okay, 2 more questions, and that's going to get to all of them, which is great. Where do you suggest storing finalized trust and legal documents?
That's another great question. So, okay, we're in the modern world. Everything is digitized. It's not like the old days where you had to keep paper, because a digital version of your documents will be available in the event you have a fire or a flood or they're lost in some way. And so there's 2 things that happen. Here's what lawyers do. We don't. Lawyers keep the original documents. Why is that? Because they want the work after the person who dies, right? Actually dies. So it's a way for lawyers to keep the business, right? I don't want anybody's plan in my office. We send it away. And then we take the executed documents and we put them up into the cloud, and they're there. And so if they're lost, they're not lost. They're never lost. And so it cuts down on paperwork for us, because there is a lot of paper in estate planning. But you don't need to put it in a safe deposit box. I tell people, because it comes, most estate planners will have a notebook that's tabbed, where you keep all your important documents, all of them, deeds, life insurance policies, obviously estate planning documents. And I say, here's what you do. You tell your successor trustee, who's like an executor, right, where your notebook is if something happens to you. It's in the, lower left-hand desk drawer, right? That's what you do. People feel quite insecure about that, and they will often put them into a safe deposit box.
Okay, we are over time, so we can do these last 2 briefly. For S&T, can you explain and confirm if we have to get a number back from the IRS to establish connect to bank account?
No, use your Social Security number.
And then do you have a list of special needs estate planners by state that you can recommend?
I can't. To make a recommendation, you have to know somebody, or you have to know that person's work. The best thing I can tell you is what I started with. Find a lawyer who does estate planning, so that person is experienced and has special needs trust planning experience as well, because the language is really important to get right, so the IRS will not attack that asset once it comes to your child.
Okay, thank you so much. I think it's just so hard to break something like this down into an hour. So thank you, Rick. It was excellent.
You're welcome. Thanks for coming.
People from all over. I think it was an excellent talk, so thanks for joining.